For those commenters online, we are just having some technical difficulties at the current moment, and hopefully we'll be getting the hearing started soon. Thanks.
All right, good morning. This hearing is called to order. Today is Wednesday, September 11, 2024, and the time is 9 a.m. This is the time and place set for the public hearing on proposed amendment of Administrative Rule of Montana 38.5.1909 pertaining to the creation of a legally enforceable obligation, otherwise known as an LEO. I am James Brown, President of the Montana Public Service Commission, and I will preside over this hearing by the PSC. I would note for the record that Vice President Fielder and Commissioner Bukacek are also present today, as well as Commission Attorney Dan Poco. Montana law requires the presiding officer at a rulemaking hearing to read the following notice, which I will read. Notice of functions of Administrative Rule Review Committee, interim committees, and the Environmental Quality Council. Administrative Rule Review is a function of interim committees and the Environmental Quality Council. These interim committees and the EQC have an administrative rule review, program evaluation, and monitoring functions for the following executive branch agencies and the entities attached to agencies for administrative purposes. For the Economic Affairs Interim Committee would be the Department of Agriculture, the Department of Commerce, Department of Labor and Industry, Department of Livestock, Office of the State Auditor, otherwise known as the Commissioner of Securities and Insurance, Office of Economic Development, the Division of Banking and Financial Institutions, the Alcoholic Beverage Control Division, and the Cannabis Control Division. For the Education Interim Committee, we have the State Board of Education, the Board of Public Education, the Board of Regents of Higher Education, the Office of Public Instruction, the Montana Historical Society, and the Montana State Library. For the Children, Families, Health, and Human Services Interim Committee, we have the Department of Public Health and Human Services. For the Law and Justice Interim Committee, we have the Department of Corrections and the Department of Justice. For the Energy and Telecommunications Interim Committee, we have the Department of Public Service Regulation. For the Revenue Interim Committee, we have the Department of Revenue and the Montana Tax Appeal Board. For the State Administration and Veterans Affairs Interim Committee, we have the Department of Administration, the Montana Public Employee Retirement Administration, Board of Investments, the Department of Military Affairs, Office of Secretary of State, Office of the Commissioner of Political Practices. Transportation Interim Committee, we have the Department of Transportation and the Motor Vehicle Division, which resides under the Department of Justice. The Environmental Quality Council, we have the Department of Environmental Quality, the Department of Fish, Wildlife, and Parks, and the Department of Natural Resources and Conservation. For the Water Policy Interim Committee, we have the Department of Environmental Quality, the Department of Fish, Wildlife, and Parks, and the Department of Natural Resources and Conservation. These interim committees and the EQC have the authority to make recommendations to an agency regarding the adoption, amendment, or repeal of a rule, or to request that the agency prepare a statement of the estimated economic impact of a proposal. They may also poll the members of the legislature to determine if a proposed rule is consistent with the intent of the legislature, or during a legislative session, introduce a bill repealing a rule or directing an agency to adopt or amend a rule, or a joint resolution recommending that an agency adopt, amend, or repeal a rule. The interim committees and the EQC welcome comments and invite members of the public to appear before them or to send written statements in order to bring to their attention any difficulties with the existing or proposed rules. Mailing address is P.O. Box 201-706, Helena, Montana 59620-1706. All right, with the perfunctory matters now taken care of, let's move to the proceeding. The notice of public hearing.
Mr. President.
Yes, Commissioner O'Donnell, welcome.
Mr. Point of order, I just wanted to announce that I am on the line also. Thank you.
Very good, thank you. And I apologize for missing you. I'll restart. The notice of public hearing for this hearing was published on August 9, 2024 in the Montana Administrative Register as MAR notice number 38-5-263. Copy of this notice can be found on the Secretary of State's website at https://mt.gov/ARM/register. I will now take a moment to go over the notice of proposed amendment. In this notice, the Commission proposes to amend its rules concerning the establishment of a legally enforceable obligation by a qualifying facility, otherwise known as a, quote, QF, under the Public Utility Regulatory Policies Act of 1978, also known as PURPA. PURPA defines a relationship between utilities and qualifying facilities. Under PURPA, utilities must purchase energy and capacity from a QF at a rate not exceeding the utility's avoided cost. For purchases subject to a legally enforceable obligation, the avoided cost of capacity is calculated at the time the legally enforceable obligation is formed. Commission's proposed amended rule, which can be found in paragraph 3 of the notice, creates standards through which an existing operational qualifying facility can obtain a new legally enforceable obligation. As currently written, this rule requires all qualifying facilities to demonstrate financial commitment and commercial viability to form a legally enforceable obligation. Existing qualifying facilities have already demonstrated financial commitment and commercial viability, and as a result, the current rule does not provide meaningful guidance to utilities and existing qualifying facilities about the formation of an LEO. The rule contemplates amending the rule by adding subpart 2, which would establish documentation requirements for existing QFs that have achieved commercial operation to establish a new legally enforceable obligation. Also, in paragraph 3 of this notice, the proposed amended rule modifies subpart 1 little b Roman numerical 4 to mirror the written statement required in the new subpart 2 little c. Paragraph 4 indicates that interested persons may present their data, views, or arguments either orally or in writing at today's hearing or after this hearing to the Commission. This paragraph also includes a deadline for comments, which I will discuss in a moment. Paragraph 5 notes that a commissioner or a duly appointed presiding officer will preside over the hearing, which I am presiding. Paragraph 6 notes that the Montana Consumer Council is available to represent the interests of the consuming public. Paragraph 7 describes the process for joining the Commission's interested persons list for administrative rulemaking. Paragraph 8 directs the reader to the Secretary of State's website to review the proposed notice. Paragraph 9 concludes that the bill sponsor contact requirements of state law do not apply to this rulemaking. Paragraph 10 states the department has determined the proposed rulemaking will not significantly and directly impact small businesses. The purpose of this hearing is to receive public comment regarding the proposed rule changes. In addition to this hearing, written comments regarding the proposed rule may be submitted to the Commission. All written comments must be submitted to the Commission no later than 5 p.m. on September 12, 2024. That would be tomorrow. Following the close of the public comment period, the Commission will summarize and respond to any comments received. Summarized comments and the Commission's responses will be published in the Montana Administrative Register as part of the rulemaking process. All right, let's move into the public comment of this proposed rulemaking. We will start with any proponents of the rule. Mr. Simpson, please state and spell your name for the record.
Good morning, Commissioners. My name is Taylor Simpson. That's TaylorSimpson. I'm here today on behalf of Hydrodynamics. First, I just wanted to thank the Commission for the smooth and straightforward rulemaking process that has occurred. The roundtable discussion was especially helpful in talking through these issues and working together to come up with a proposed rule that is satisfactory to all parties involved. Hydrodynamics believes that this new rule on existing qualifying facilities provides needed clarity on an issue that has not yet been addressed by Commission rules. Existing QFs have already demonstrated financial commitment and commercial viability. Therefore, the current rules are difficult to apply to existing QFs. Hydrodynamics supports the Commission's proposed red lines to the rule. for reasons previously stated in our written submitted comments. Additionally, Hydrodynamics supports the proposed requirements for new qualifying facilities to provide a written statement with key terms demonstrating commitment. Hydrodynamics believes this proposed requirement is consistent with FERC direction. Again, I'd just like to thank the commission for making this a painless process and for allowing the opportunity for collaboration between parties and reaching this hopefully mutually agreed upon rule. With that, Hydrodynamics will rest on our previously submitted comments. Thank you.
All right. Thank you, Mr. Simpson. Thank you for your comments this morning. Any other proponents of the proposed rule in the room? Seeing none. Are there any opponents of the proposed rule in the room? Seeing none, are there either proponents or opponents of the rule online? I can just call based on the names given to me by our staff as to who may be commenting this morning. Ms. Norcott, are you on? Would you like to comment?
I am. Thank you. And I would like to comment. Good morning, Mr. President, Madam Vice President, Commissioners, and esteemed staff. My name is Sarah Norcott, last name spelled Norcott, and I'm here today to offer comments on behalf of Northwestern Corporation. Northwestern also supports the Commission's proposed amendments to Administrative Rule of Montana 38-5-1909. Northwestern initiated this rulemaking through a petition that was filed in January with the goal of gaining clarity as to how existing facilities, qualifying facilities, or otherwise known as QFs, can establish a legally enforceable obligation, or LEO, for a new contract when their current contract expires. This new rule, in our opinion, satisfies that goal and will help Northwestern and QFs manage the process for negotiating new contracts. Northwestern is particularly appreciative of the Commission's willingness to conduct a roundtable in this matter so that commenters could meet face-to-face and work together to make the rule as clear as possible. In the proposed rule, there is a requirement for a written statement, and Northwestern requests that the Commission clarify the requirements for a written statement and whether that statement needs to be signed. Northwestern filed comments on August 27th, suggesting that the rule requires written statements to be signed. Again, Northwestern appreciates the opportunity for comment that the Commission has afforded interested stakeholders in this rulemaking proceeding, and Northwestern supports the changes that are proposed in the notice of proposed amendment. Thank you for the opportunity to comment, and thank you again.
All right. Thank you, Ms. Norcott, for your comments and time this morning. Mr. Chandler, you're up next on my list. Good morning.
Good morning, commissioners and commission staff. I don't have much more to say than what Mr. Simpson said. I'm here on behalf of Hydrodynamics as well. Other than to just reiterate that really appreciated the commission staff throughout this process, working through the roundtable as well as the parties. I think it's a good exemplary rulemaking process moving forward, and I appreciate the proposed rule as written.
Thank you, Mr. Chandler. Appreciate your time this morning and your comments. All right, Austin.
Yes.
I'm afraid of butchering your last name.
Though I'll do it
before the commission. Go ahead.
Good morning, commissioners. My name is Austin Rushoff. I'm with the law firm of Holland and Hart, and I'm appearing on behalf of Colstrip Energy Limited Partnership and Yellowstone Energy Limited Partnership. These entities are also known as KELP and Yelp. KELP owns the Rosebud Power Plant located near the city of Colstrip, which is a coal refuse-fired electric generation facility. And Yelp owns a power plant located near Billings, Montana, which generates energy from petroleum coke. Both of these facilities are qualifying facilities, and KELP and Yelp currently sell power to Northwestern Energy pursuant to QF power purchase agreements. Both of these facilities have been in operation for decades and have provided Northwestern with baseload, reliable, dispatchable energy. I don't know if our comments are supportive or in opposition. Our comments in this proceeding, as we filed in written format a few times, are more procedural than substantive. We do not take a position necessarily on the rule as proposed. Rather, KELP and YELP's interest in this proceeding is to ensure that any rules adopted are only applied prospectively. KELP and YELP, as QFs with current agreements with Northwestern, has some concern that if it's not made clear in the commission's proceeding that any adopted rule is only applies prospectively, it could have the unintended consequence of modifying or creating controversy in sort of existing arrangements between QFs and utilities. And that is something KELP and YELP would like to avoid and believe that's in the best interest of utilities and all QFs in the state. So in our written comments, we've asked that in the commission, in any final order that it adopts, includes language in the order itself clarifying that the rule should only be applied prospectively. We think this is non-controversial. We participated in workshops with the other parties. I think all other parties agree, and we see this as more of a housekeeping comment rather than anything substantive for the rule. So I thank you for your time and welcome any questions.
Thank you, Ms. Rushoff. Appreciate your time this morning and your comments. All right. Is there anybody in the room that would like to make comment? Anybody in the room that would like to make comment? Seeing nobody? Is there anybody else online that would like to make comment? Anybody else online who would like to make comment? Seeing none. Well, thank you for all those that provided public comment this morning and participated in this proceeding. I would just note for the record that the commission maintains a list of interested persons and the subjects in which each person on the list is interested. Within 3 days of any rulemaking notice being published, all interested persons are notified about the rulemaking activity. If anyone here today would like to be placed on the interested persons list, please use the meeting sign-in sheet for those that are in attendance in the room in the reception area to indicate your wish to be included on an interested persons list. Seeing no further public comments, the time is now 9:24. I will now close the rulemaking portion of this public hearing. However, pursuant to Montana Code Annotated Section 2-3-103, every commission meeting must include an opportunity for public comment on any public matter that is not on today's agenda, but that is within the commission's jurisdiction. Is there anybody in the room that would like to make a public comment on any matter within the commission's jurisdiction that was not involving today's hearing? Seeing none, anybody online that would like to make public comment? Seeing none. All right, with that, again, I think we all know the significance of today's date, 9/11, and what happened some 23 years ago. Let our hearts and minds go to the victims of that terrible tragedy and to their families, and let's hope that this country will keep them in their hearts and their minds every day, and that we will act like we did on 9/12/2001 moving forward. All right, I will conclude today's meeting. Time is now 9:26.